Hello friends, very warm welcome to my business class channel. Till now friends, I have covered up to chapter number 10 under the ICA 1872. Today I am going to take a new act which is the Sale of Goods Act 1930. Sale of Goods Act 1930 before 2019 it was applicable to the whole of India except the state of Jammu and Kashmir. But after J&K Reorganization Act 2019, now it has been made applicable to entire India, including the state of Jammu and Kashmir. And now, friends, chapter number 14 to chapter number 18, they are from the Sale of Goods Act 1930. So I'm going to take up chapter number 14 today. So this is the first chapter, Nature and Formation of Contract of Sale. Now under this, 4 to 5 headings are very, very important. Meaning of contract of sale and then meaning of agreement to sell. Distinction between sale and agreement to sell. Features of contract of sale. And then after that, classification of goods and what is the subject matter of contract of sale. And then how is the price determined under the contract of sale? Another question which is asked in the examination, that is, what is the effect of perishing of goods? So all these headings, friends, I am going to take up in this video lecture. So what is contract of sale? The contract of sale has been defined under section 4 subsection 1. A contract of sale is a contract whereby the seller transfers or agrees to transfer the property in goods to the buyer for a price. So if he transfers the property in goods to the buyer for a price, it is known as sale. And where the transfer of property in goods is to take place at a future time or subject to some conditions thereafter to be fulfilled, then the contract is known as an agreement to sell. So friends, this definition which is given under section 4 subsection 1, it includes both sale as well as an agreement to sell. Now, moving ahead, now when does an agreement to sell become a sale? When conditions are satisfied or the time lapses, then the agreement to sell will become sale. Now, what are the essentials of a contract of sale? So friends, there are 6 points regarding this. I would like to explain. The very first point is there must be at least 2 parties. Out of 2, one should be the buyer, other should be the seller. Now, no person can buy his own goods. So there is the sale of contract of sale is a bilateral contract. So consisting of 2 parties, one as the buyer, other as the seller. A contract of sale may be express or implied. So contract of sale may be express or implied. Express means verbal or written, and implied is always inferred from the circumstances of the case or from the conduct of the parties. The mode of formation of contract of sale. Now section 5 provides the mode of formation of contract of sale. The goods may be delivered immediately, but the price may be paid at a future date. Or the delivery of the goods may be done at a future date, but the price of the goods may be paid immediately. Or the price may be paid in installments. Similarly, the goods can also be delivered in installment. Next feature is transfer or agreement to transfer the property in goods. So property in goods means ownership. If the property in goods is transferred immediately, then it is known as sale transaction. And if it is transferred at a future date or subject to some conditions, then it is known as an agreement to sell. Coming to the next point, which is subject matter of a contract of sale. Subject matter of a contract of sale must be goods. The subject matter of the contract of sale should always be goods. The goods may be either existing goods or future goods. So under the classification of goods, I will explain in detail the meaning of existing goods or future goods. Price is the consideration of the contract of sale. The last line of the definition, which is given under section 4 subsection 1, it provides that the transfer always takes place for a price. So transfer of property must take place for some consideration, which is known as price. Goods are exchanged against goods, then it is known as barter system. But under the contract of sale, partly the goods can be exchanged and partly consideration can be in the form of money. So having discussed the essentials of contract of sale, and now friends, I would like to talk about the distinction between sale and an agreement to sell. This is a very, very important heading from examination point of view. Distinguish between sale and an agreement to sell. There are 8 points of distinction. I'll take up all the points and explain. First is the ownership. This is the very important point, basis of distinction between sale and an agreement to sell. Ownership is transferred from the seller to the buyer immediately, but in case of an agreement to sell, ownership transfer takes place at a future date. Now, sale is executed contract, but sale is executory contract because ownership is to be transferred at a future date. The subject matter of contract of sale is ascertained goods or specific goods, but subject matter of agreement to sell is future and unascertained goods. So friends, all these terms I will clarify under the heading classification of goods. Nature of rights. Sale always provides the rights to the buyer, which are known as jus in rem. Jus in rem means rights against the whole world. Buyer becomes the owner. But in case of agreement to sell, buyer gets the rights jus in personam. The rights are available against individual only. Next is risk of loss. Risk prima facie passes with property as per section 26. Whosoever is the owner of goods has to bear the loss of destruction of goods. So in case of sale, buyer has to bear the loss. But in case of an agreement to sell, seller has to bear that loss because ownership is with the seller. Buyer's failure to pay the price. If there is a default on the part of buyer, then in case of sale, seller has a right to sue the buyer for a price. But this right is not available to the seller in case of an agreement to sell. He can only recover damages. Now, if there is a default on the part of seller, then in that case, buyer can file a suit against the seller for recovery of goods. But in case of seller's failure to deliver the goods in case of an agreement to sell, the buyer can only recover damages. So friends, remember, whether there is a buyer's default or seller's default, the damages can be recovered in case of an agreement to sell. Goods can be recovered by the buyer from the seller. Price can be recovered by the seller from the buyer. Right to resell the goods. In case of sale, seller has no right to resell the goods. Resale is not valid. But in case of an agreement to sell, seller has a right to resell the goods. Resale will be termed as valid. So these are the points of distinction between sale and an agreement to sell. And now this kinds of goods or classification of goods is another very important heading from examination point of view. Goods form the subject matter of a contract of sale. We can classify the goods into 3 categories. First is existing goods, future goods, and third is contingent goods. Existing goods, by existing goods, we mean the goods which are owned and possessed by the seller at the time of formation of contract. Existing goods may be either specific goods or ascertained goods. Now, then we have the specific goods. Specific goods are those goods which are identified and agreed upon by the seller and the buyer at the time of formation of contract. But ascertained goods are the goods which are identified by the buyer, subsequent to the formation of contract of sale. Now, future goods are the goods which are not in the possession of the seller. These goods are to be manufactured, produced, or acquired by the seller after the formation of contract of sale. So these goods may be either not in existence or in existence but not yet acquired by the seller. Say, take the examples of vegetables which are to be grown, machinery which is to be produced, or item is there but it is not in the possession of the seller. So all these goods will fall under the category of future goods. Now, contingent goods are the goods acquisition of which by the seller depends upon an uncertain contingency. These are known as contingent goods. Now, they are a type of future goods, and therefore a contract for the sale of contingent goods always operates as an agreement to sell and not a sale, so far as the question of passing of property to the buyer is concerned. Say, for example, friends, machinery is coming on the ship. The arrival of the ship is not certain. Ship may arrive or may not. If ship arrives safely, then the machinery will be sold by the seller to the buyer. But if the ship does not arrive safely, it is sunk on the way, then the valid contract will be transformed into void. So friends, I hope you must have understood all these kinds of goods. Existing goods, future goods, and contingent goods. But remember, friends, when we talk about future and contingent goods, then there cannot be sale transaction. There has to be an agreement to sell. Now, what is the subject matter of contract of sale? This is also an important question which is asked in the examination. What do you mean by the subject matter of contract of sale? What does it include and what it does not include? So, subject matter of the contract of sale includes these various items, and these items have been decided on the basis of case laws. In the various case laws, judges have held that subject matter of the contract of sale will include all these items. First is movable property. The contract of sale is always concerned with the movable property. Things attached to land, trees, crops, electricity, gas, steam, water, the decree of the court. Decree is the order of the court. That is also within the purview of goods. Electricity signals such as cable, TV signals, they have also been regarded as goods. And then stock and after the allotment shares have also been included in the category of goods. FDRs, they are also goods under section 176 of ICA 1872. Animals, birds, they have also been put under the category of goods. Foreign coins or old and rare coins, they also form the subject matter of contract of sale. Intangibles like goodwill, copyright, trademark, patents, they are also treated as goods and may form the subject matter of contract of sale. Now, money, but there are certain items which are excluded from the definition of the contract, from definition of goods, from the contract of sale. The goods, the subject matter of the contract of sale does not include these. First is the money, then actionable claims, then immovable property, the services, lottery. So money cannot form the subject matter of contract of sale within the definition of section 2, subsection 7 of the Act. Actionable claims. Actionable claims are those claims which can be enforced through legal action only. Debt is a very good example of actionable claims. It cannot be sold, it can only be assigned. Immovable property. So immovable property has been regulated by the transfer of Immovable Property Act 1882. Lottery. Lottery cannot be regarded as goods as it falls within the definition of actionable claims. Services are different from goods. Services and goods, they cannot be used interchangeably. So services are different from goods. They are outside the purview of subject matter of contract of sale. Now, friends, having discussed classification of goods and what is the subject matter of contract of sale. And now, friends, I would like to take up the next question. What do you mean by perishing of goods? And what is the effect or impact of perishing of goods? Sections 7 and 8 deal with the effect of perishing of goods on the right and obligation of the parties to a contract of sale. Under these sections, the word perishing means not only physical destruction of goods, but it also covers. So what is the meaning of the term perishing of goods? Perishing of goods doesn't mean the goods should be physically destroyed. Sometimes the goods are there, but their utility is lost. They are not fit for commercial use. Then also we will say the goods have perished. Say for example, when water gets mixed up with cement, that does exist, but it is not for use. It cannot be used now. Now, sugar becomes sharbat when it gets mixed up with water. Okay, so the item is there, syrup is there, but it is not for use now. It cannot be used. Second is the loss of goods by theft. Goods are stolen, then also this will be included under the perishing of goods. Then where the goods have been lawfully acquired by the government. Lawfully acquired by the government. So all these means perishing of goods. And now friends, after this I would like to take up what is the impact or effect of perishing of goods. So this I would like to take up under two headings. First is specific goods perishing before making of the contract. So friends, remember this section 7 and section 8 both are applicable in case of specific goods. Specific goods are the goods which have been identified and agreed upon by the buyer and the seller at the time of formation of contract. So goods are specific goods. If they are future goods, unascertained goods, then in that case, sections 7 and 8 will not apply. So the first is specific goods perishing before making of the contract. So here I would like to discuss 2-3 points. First is where the goods perish at or before making of the contract, but it is not known to the parties, then the agreement will become void. It will be void because it is not the fault of the parties. Parties were not aware of the fact. So agreement will be void. Where only part of the goods have destroyed. So what will happen, friends, if part of the goods are in good condition and other partially goods have destroyed? Then, friends, is buyer bound to accept the goods which are in good condition or not? It depends. It depends upon the nature of contract. If the contract is divisible, then buyer is bound to accept those goods which are in good condition. But if the contract is entire, non-divisible, then the buyer is not bound to accept the goods which are in good condition. So friends, I have discussed the provisions which are contained under section 7. Now provisions which are contained under section 8, that is specific goods perishing after an agreement to sell but before sale. Friends, I hope you must have understood these two concepts. One is agreement to sell, second is sale. So agreement to sell has taken place, but sale has not taken place. It means the ownership is still with the seller. So goods have perished after an agreement to sell but before sale. Then in that case, the rule of subsequent impossibility will apply. The goods have perished now. Okay, then the valid contract will be transformed into void. So you all know, friends, what is the effect or impact of subsequent impossibility of contract. So the contract will become void. If the party has derived any benefit, then the principle of restitution will apply. Now, next heading which I would like to consider is ascertainment of price. The transfer of property and goods from the seller to the buyer, it takes place for a price. It has been contained in the definition of contract of sale, which is given under section 4 subsection 2. So there are certain modes of ascertainment of price. Price may be expressly stated in the contract. Price may be fixed in a manner provided by the contract. Price may be determined by the course of dealings between the parties. Price may be the reasonable price, or price may be determined by valuation of a third party. So broadly speaking, friends, there are 5 modes of ascertainment of price. Sometimes this question is asked in the examination. Which are the various modes of ascertainment of price? It may be stated in the contract itself. And second is, it may be fixed in a manner provided by the parties. Parties may decide that which price may be has to be given by the buyer to the seller. Then price may be determined by course of dealings between the parties. That is, if the customer is a regular customer and the seller has been permitting him discount at the rate of 20%, then that buyer will get 20% discount, and that price, discounted price, the buyer will have to pay to the seller. Reasonable price. Whatever is a reasonable price. By reasonable price, we mean the price, market price on the date of delivery of goods. That price, the buyer will have to pay to the seller. Then price may be determined by valuation of a third party. They may decide whatever value is given by the third party, that price the buyer has to pay to the seller. So third party will decide the price, and that price the buyer will have to pay to the seller because it is acceptable to both the parties. So friends, these are the various modes of ascertainment of price. Last heading which I would like to consider is stipulation as to time. Section is 11. There are two types of stipulation. One is stipulation relating to the time of payment of price, and second is stipulation relating to the time of delivery of goods. Remember friends, under the contract of sale, stipulation relating to time of delivery of goods may be considered as the essence of the contract. If the time has been specified by the seller regarding delivery of goods, then it becomes a duty of the seller. He must deliver the goods within the specified time. If he does not deliver, he fails to deliver the goods within the specified time, then the buyer will have the right to put an end to the contract. The buyer will have the right to avert the contract. So friends, this is all about the Sale of Goods Act, chapter number 14. Now I would like to conclude what all headings I have covered in my video today. First of all, I did talk about the contract of sale, meaning agreement to sell, then essential features of contract of sale, and then after that classification of goods, and then subject matter of contract of sale, distinction between sale and an agreement to sell. Perishing of goods. What is the meaning of perishing of goods? What is the impact of perishing of goods? What are the various modes of ascertainment of price? Then the last heading which I have covered is stipulation as to time. So it's all from my side, friends. I hope you must have understood the content. Do like my videos. Do subscribe to my channel. If you have not subscribed yet, do press on the bell icon to get notifications of my subsequent videos. Okay, friends, goodbye. We will meet soon.